Good afternoon.
Showing up today. I guess you don't have an opponent showing up today, Mr. Rudge.
I guess I don't have to reserve any time.
There you go. So, nor do you have to use all of your time.
Right.
So, how about it?
May it please the court, Timothy Rudge on behalf of the appellant, Jupiter Asset Recovery. This case is simple. The trial court erred. They made factual findings and legal conclusions that weren't based upon any evidence in the trial court, nor on any pleadings, affirmative defenses, causes of action, or anything, basically. The background of the case is this is an interpleader action. It's brought by the clerk relating to a tax deed surplus sale. Jupiter obtained their rights under an absolute assignment from the personal representative of the estate of Daniel Russo. The PR's name is Sutherland.
So the trial court based it on the advisory opinion, and you talked about facts. Let me cut to the chase for my purpose.
Please.
The daylight between the facts of the Florida Bar advisory opinion as I understand them is that in the Florida Bar, the same exact individual in the advisory opinion made filings in the court. Here, he hired an attorney to do that. But isn't the advisory opinion susceptible, actually probably the most reasonable interpretation, that each of the different bases for an unauthorized practice of law stood on its own? In other words, it wasn't necessary for the finding of the unauthorized practice of law that the individual filed filings in the circuit court. It was sufficient that he actually made the filings he did before the clerk for the holding of unauthorized practice of law. Would I be correct?
Kind of. There's some problems with the analysis. The one thing that makes this a little bit different is we're dealing with the same individual. So if you take the precedent of the advisory opinion, it's like a case law. So what you have to do is apply those facts that occurred in the Wall matter, apply them to these particular facts, and see if you hit the circumstances that the advisory board said is UPL. There are differences in the facts. I will tell you that, but probably more problematic is the idea that nobody brought this. This would be Sutherland's claim to bring. She should have brought a cross claim against Jupiter alleging UPL or alleged affirmative defense. She does.
Let's stay on the facts. Could you mind staying on the facts since I asked that question? And
absolutely.
Tell me what the differences are. So go ahead and do it now.
Yes. In the Wall case, Mr. Wall believed that Mr. Payne was a lawyer. Okay.
That was another distinction. Okay, so we have that distinction. We have the distinction, and then the Wall case. Mr. James actually made filings in the circuit court. So leaving those aside, the facts seem very close.
Well, it's the same party, and it's an assignment and an agreement. But short of that, we would need our day in court to be able to argue that. You can't just say pull the documents together and say this is the same thing, because the facts are different. Ryan Shirley, who was the attorney for Jupiter at the time, spoke with Ms. Sutherland on the phone, so she was well aware that they were not lawyers, that she was dealing with Ryan Shirley as an attorney.
That's not a sine qua non to unauthorized practice of law. You don't have to. You could have a willing quote unquote client and still participate in the unauthorized practice of law by doing things on behalf of that client who knows you're not a lawyer.
Agreed. Another distinction between the two cases is the agreement. Jupiter routinely uses an absolute assignment and agreement. One of the issues that was raised in Wall was the idea that the agreement wasn't disclosed to the court. Attorney Shirley, in his motion for disbursement, attached the agreement. So that's
just fraud on the court. It may have borne upon unauthorized practice of law. But here there was no fraud on the court. what you're saying.
And also, I think that is a different fact from the Wall case. And the other thing that we have to remember with the Wall case is that's one side of facts. That's Mr. Wall's facts. When you read the transcript, I know it's not part of this record, but when you read the transcript from the hearing, it's not really testimony that's cross-examined. It's the committee asking questions of particular individuals who were there. Wall provided no testimony. His lawyers did, and it is those facts were never, what he said occurred were never proven. They were, what the advisor opinion said is, okay, if these particular facts occurred, then we can take these facts and plug them into another circumstance and say, do we meet this criteria? Are these things equal unauthorized practice of law? I'm not assuming that Wall's rendition of the facts at the advisory opinion are accurate, nor was that ever
We
proven.
can't do that in recorded opinions. I mean, I understand the Supreme Court adopted the advisory opinion, right?
Supreme Court adopted the advisory opinion to the extent that this is the criteria that you look for when you're trying to determine if a recovery company is engaging in UPL, not that the Supreme
Judge
Court.
Northcutt writes an opinion, and there's a bunch of facts in there. I just assume the facts.
Right, but we're talking about two separate cases. It's like any other piece of case law that you would.
I don't understand what you're saying. You're saying, I thought you said I can't assume that the facts in a recorded opinion of the United States Supreme Court were the facts of that case.
Well, it's one side of facts. Those facts were never tested. There was never an opportunity to put evidence on and cross-examine those facts at the hearing. It was just testimony. It was just one-sided where there's no opportunity to cross-examine. And then the Supreme Court adopted the committee's recommendation that these are the particular factors that you're looking at in the world.
In other words, what I'm saying, even if it didn't happen, the
Right.
Supreme Court said, if this were to have happened, this is the unauthorized practice of law.
I agree with that.
That the trial court cannot apply that to the facts before him or her?
The trial court can apply that to the facts before her, but it cannot be raised by the judge. The judge cannot be an advocate. That would be like.
So now we're on a separate issue, I think, right? Now
I think it's part of that. It's like if I bring a breach of contract case and I have a claim for breach of contract and one for unjust enrichment, and then at the trial, at a bench trial, the judge says, well, I'm going to go ahead and you didn't plead it, but I'm going to do a fraud and inducement or a negligent misrepresentation claim. It doesn't exist. It doesn't exist there.
But the trial court, okay, I see that. But the trial court is being asked to enforce a document. And would you agree or disagree with the trial court's conclusion? Let's say he found this sufficiently in your mind, based on facts adduced, that this was in a product of unauthorized practice of law, and is the trial court obligated to? Would you agree with the trial court's supposition that it's void ab initio? And if that's the case, is the trial court now permitted to take that into consideration when being asked to enforce an agreement?
Well, here's my take on that. There was a motion for disbursement filed, and there was a memo in opposition filed by Sutherland. Those issues weren't addressed, so I don't think the court can go beyond that. That would be like a court going beyond and advocating terms of a contract and reading things into a breach that wasn't alleged. I don't think it's up to the judge to do that. I think that in the Goldberg case states there is a private cause of action for somebody who feels like they're a victim of UPL that can be brought.
That's what they wanted damages. Here we're not talking about damages.
Agreed, but one way to get at what you're talking about was if Sutherland raised it as affirmative defense or a cross claim against Jupiter. Instead, she raises some other things, and at the hearing, the transcript, which is part of this record, Attorney Shirley states she, talking about Sutherland, didn't provide any legal basis or valid reason to cancel the agreement. And then the judge, the court speaking, says the motion will be denied, and she's denying it based upon the Wall opinion and the Goldberg case. And there's nothing in the record to even be able to raise that. And
so, in other words, you're saying if someone, a non-lawyer, enters in an agreement with a client, for lack of a better term, and wants to enforce that agreement against a client, and the agreement was the product of an unlicensed practice of law, because that quote unquote client doesn't have the means to appear, doesn't know whether to appear, decides they don't care enough, that the trial court has to enforce that agreement against a quote unquote client of the litigant and cannot decide that it's unenforceable because the quote unquote client didn't appear.
It's a great question. It's a great question. This is how I would respond. This is how I would respond to it. If the judge has that concern, and I'm not a judge, I can't speak to what remedies the judge could take. But one thing the judge could have done was to take some evidence. There's no evidence here. You know, when you take a look at how you review this, on what standard you use, no evidence was taken in.
The judge says on the face of the filings.
Right. So can you tell that's a leap. Can we tell from the face of the filings? Can we tell by the face of the assignment and the agreement that this equals UPL? I think that's very broad. I think it's even broader than the wall decision. I don't think you can. I think you have to take some evidence. Well, I think you have to take some evidence of testimony.
You know what the judge relied on, and I do, and we know the record.
Yeah. I would say
so
back.
Why not?
I would say back to that needs to come from the legislature.
Go ahead, sir. Sorry.
They need to pass a law that says that recovery companies can't do this. Because I could tell you, if you read, and it's not part of this record, but if you read the transcripts from the wall, there was a company called Global, and their attorney gave some testimony. And my understanding from that testimony is there is a cottage market of these recovery companies that are doing very similar, if not exact same procedure that Jupiter is doing. So by saying that, you would be saying that in every county, that all these recovery companies that are doing this through assignments and agreements equals UPL. I think that doesn't even make sense. And if you're gonna
I don't know if that addresses my question about what the trial court was able to ascertain from the filings in the interpleader action, whether based on what he was able to ascertain, not talking about the other companies that you're.
I get your question now.
Why doesn't the advisory opinion support the trial court's finding of invalidity?
At best, we don't know. At best, we don't know. Just looking at what the record is, looking at the agreement, the assignment, and the documents that were attached to the motion for disbursement. We don't know. We would have to do a full analysis of the Goldberg case and the Wall case and see if it equals these allegations. Just because there's been an agreement and an assignment by a recovery company doesn't necessarily mean that's unauthorized practice of law. That's not my understanding of Goldberg and Wall. Not to mention my previous argument. Not to go back to what I said before. I don't think the judge can read into that contract, right? I mean, that would be like if there is a trial, if there's a bench trial and we're dealing with a breach of contract, I don't think the judge can read through each paragraph of the contract and bring a new cause of action or a new remedy under a particular paragraph that hasn't been raised in the pleadings.
So under the opinion, it breaks down each instance of activity that in and of itself could be constituted. Right. So here, J.A.R. Payne was representing Wall because Wall still had an interest in litigation. This was not a situation where Wall signed over all the interest and Payne offered Wall a contingency fee. Wall was a party to the action, therefore he's being represented by Jupiter. By so representing Wall in front of the clerk, he engaged in the unlicensed practice of the law. Isn't that what happened here?
It's not what happened. I'm not necessarily sure that's technically what happened in Wall. I think that's Mr. Wall's opinion on what happened in Wall, and I would cite the court to Goldberg. I think what you need to do in this particular case is a two-step test. If you read Goldberg, determination by the Supreme Court, and if you have that in Wall, so you move to the second. You have to state a cause of action with the proper pleading that something is UPL, and then you have to apply the facts from Wall and Goldberg to this case. And I think it's an oversimplification just to say that there's an assignment and a contingency fee agreement that equals UPL. And if the court, first of all, if the court would rule in that direction, I think it would have a very broad, it would broaden the case law, certainly on Goldberg. It would basically eliminate the business practice of these particular recovery companies being able to use agreements and assignments. I don't think you could get there from reading Wall and Goldberg in this particular case. I mean, yes, you're dealing with the same person and you're dealing with similar agreements, but the facts are different, and there was never an opportunity in the lower court.
This is your chance to tell us the pertinent differences in the facts.
Well, I've told you. I think one of the very important differences, and the court may disagree with me, but I think one of the important differences is that Mr. Wall believed that Mr. Payne was a lawyer. That screams UPL to me. In this particular case, a lawyer was talking to
I get it. We covered that. I acknowledge that.
I think another important case in Wall is Wall raised it. He raised it in affirmative defenses. Wall raised UPL in interpleader case in Manatee County. Sutherland didn't. Okay, if Sutherland raised it as a defense or cross claim, I think that puts it before the court. I don't think it's even before the court to make that determination.
That's a different question than whether the facts
if,
align.
If,
That's
if,
a procedure. Okay.
If it is, I don't think there was ever the opportunity to answer the questions you're asking perfectly. I don't think we can at this point, because there's no record to support if the standard set forth in Goldberg and Wall apply to this particular case. I don't think it does, because I don't think the cases are the same. But that's just me and my speculation. There's no record. There's no record. The trial judge has no record to base her order on that says this equals.
Except all the filings in the interpleader action. Let me ask you, can you clear something up real quick for me before I forget? I'm apologizing. I'm sorry to derail your thought. Why? I think I might know, but I want you to tell me, why were you seeking in the trial court 100% of the proceeds, and on appeal you've continued that assertion that your client's entitled to 100% of the proceeds?
I'll tell you, because
are you saying that the quote unquote client repudiated the contract and she gets nothing?
No. My understanding and from the trial record is they were moving forward on the assignment. That if the case would have gone, if the judge would have granted their motion, what would happen is
by virtue of the very structure of this business, as you're
the deal, right. So
it all goes to the person who's not practicing law, and then that person gives it to the other party to the agreement that here was, that you're saying, revealed to the court.
That was correct. The assignment operates. If the court granted the motion, then the money would be dispersed based upon the agreement. I'm not disagreeing that you get to the same remedy if you look at the documents together or separate. It ends up being the same remedy, but based upon the record and what was asked for in the lower court, that's why it's carried over to the appellate world here. But I don't disagree with you. The remedy becomes the same. And the other thing I would point out that hasn't been said, that probably doesn't need to be said, but I'll say it just for completeness. Jupiter had a lawyer representing its interest in this particular case, and I could tell you from in the pleadings, I can't point you to where it's at in the pleadings, but Ms. Sutherland was told, if you want to get your own lawyer, if have a lawyer look at these documents. So I mean, Jupiter was not filing documents in the name of Jupiter in court. They weren't filing answers and motions. There was a lawyer who was actually filing.
But they did appear before the clerk of court in the tax proceedings procedure.
I think it's. I don't know if I would say that, but I think it is fair to say that there was a letter from Jupiter to the tax people regarding the tax deed surplus.
Right.
I don't know if that equals appear, but I understand your point.
That semantical question may be less important than whether that activity fits within one of the, in my reading, compartmentalized findings of UPL in the advisory opinion.
And to kind of deal more with what based on the court's questions. I mean, doing an analysis based upon the record that we currently have and trying to see if that equals UPL it doesn't make sense. It's not in the trial record. that would have had to been something that was determined at the lower court level, not at the appellate court level. It's not even in the record really for the court to consider. To say there were no appealee briefs in opposition to the appellant brief. The only brief.
Well, if you're making a due process argument or something, I think that ship has sailed.
No, I'm not making a due process. I'm just pointing out the point that Sutherland had an opportunity to appear at the hearing in October where the judge denied Jupiter's motion.
What I'm saying is if you have consternation about the fact that you were not permitted to deduce the evidence that you wanted to, then that should have made it into your initial brief.
I'm not arguing that. What I'm saying is all that's before the court is Jupiter's side of the story. There was no brief in opposition filed with the appellate court on this issue, and one could have been UPL could have been raised by the clerk. It could have been raised by Ms. Sutherland. They had obviously had notice of the notice of appeal, and there just hasn't been one. So the only entity here that has raised UPL has been the court, and I don't. To me, that doesn't necessarily make sense because to me, and I'm not going to restate what we talked about because I've already made that point. I think it's outside of the record. I guess it was an easier, simpler way of maybe saying it.
Is there any case law you have that would suggest that the trial court is not permitted to take into consideration the possibility of the invalidity of the agreement by virtue of its being a product of UPL sua sponte?
I don't have it. It's an interesting question and one that I've considered and thought about. And I could tell you from taking a look at I figured the court would have questions about UPL, so I tried to become more familiar with what happened with the advisory opinion with Wall. I wasn't involved in that, and I could tell you from my reading of it, it didn't seem like there was much case law or much on this, and the idea of what a trial judge, kind of dovetail off to your specific question, what a trial court can do at a motion for disbursement of a tax deed surplus. I don't have any case law that says one way or the other, but I can't imagine that a trial court could raise an argument as an advocate that would need to be raised by a litigant to the case. And I don't, and like I said before, I don't think what was filed, you could take those attachments to the motion and say, okay, these facts fit in. I don't think you have competent, substantial evidence to be able to say, okay, here you go.
Okay, you guys have used 20 minutes. So I'm going to call it here. Mr. Rudd, I'm thinking you want a reversal.
I do.
Okay, there's your summation.
Thank you, Your Honor.
Thank you very much. Press the leave button and you'll be out of here. And we are adjourned.
How are we going to,
I think we'll,
okay, you're going to send a timer or something?